Hey everyone, I'm Leonard French, your favorite copyright attorney, and this week I have a bunch of stories that I think you'll enjoy. In this episode, I'll give you my perspective on the Great Clown Scare of 2016, we'll discuss the latest privacy violation for airline passengers, I'll reveal how a web server company lost $2.4 million in a social engineering scam, we'll go over why the government wants huge enlistment bonuses back from veterans returning from war, and I'll talk about the video of the attorney who showed up to court drunk, possibly with a prostitute. But first, out of Cook County, Illinois, comes an update in the story of Rhonda Crawford, the woman who illegally substituted for a judge in 2 traffic court cases. Having previously lost her job over the unqualified rulings, she now faces 2 criminal charges as well as an ethics complaint. The key detail seems to be that the real judge, Valerie Turner, thought that Crawford was also a real judge, possibly because she is running for a judgeship position in Cook County, Illinois. But Judge Crawford wasn't a judge when real Judge Turner suggested that they swap places. Non-Judge Crawford did not correct the mistake and did take the judge's seat and perform the judge's duties. Citing this as dishonesty and misleading, a big deal for judges, the Illinois Attorney Registration and Disciplinary Commission is seeking to have her barred from becoming a judge, even if she wins her election. Fake Judge Crawford vows not to go anywhere. She is going to fight the good fight. It makes me wonder if Ms. Crawford's judgeship will be knocked out about as fast as Ronda Rousey fell to the surprise roundhouse from Holly Holm. Next up, clowns aren't wanted in Kemper County, Mississippi. It appears that the freakout over people dressed in clown makeup continues to sweep the United States. Now, a county council in Mississippi has reacted by banning anyone from appearing in public in a clown costume, clown mask, or clown makeup. Violators are subject to a penalty of up to $150. It's reported that police have already fined people who made creepy clown costumes in response to the recent wave of anti-clown sentiment. The clown craze seems to be fueled by some illegitimate fears, then stoked by a large number of folks who care deeply about these people's illegitimate fears. White knights. You might think that all of this is a little bit of an overreaction, and I think you'd be right. While federal, state, and local governments all have the power to regulate health and safety, that power comes up against a brick wall when they try to regulate expression and association. The First Amendment protects your right to express yourself freely and from any government prior restraint on that speech. Prior restraint is a statement or position from the government that expression of a certain kind is automatically harmful. This law may be a very good example of prior restraint in that the Kemper County government is restraining your right to wear clown makeup in public, while still allowing others to wear makeup who don't configure it to look like a scary clown face. One easy way to tell that this is prior restraint is to ask yourself, who is going to be the judge of what is clown makeup and what is not? If you're thinking, that would be a very subjective thing, not easy to be judged by a person in an unbiased manner, but rather something that is in the eye of each individual beholder, then you'd be right. And that's why it is most likely an infringement upon your right of expression and not a limitation for the purposes of safety. To compare and contrast, imagine a regulation that said that no one was allowed to wear articles of clothing that had hard or metallic spikes sticking off of them. That would be much closer to a safety regulation than an unconstitutional restraint on freedom of speech. And that's because it's easy to determine whether a person has violated the clothing spike requirement, which is much closer to a safety regulation than the look of one's clown costume. What do you think about clown makeup regulations? Does it make you feel safer to know that people can get in trouble for walking around in scary costumes at the end of October? Or would you rather see the government keep their grubby little paws off your freedom to express yourself in whatever makeup or tattoo or lack thereof that you desire? After posting this on my Facebook wall, one commenter asked what happened to the county council after the law took effect. Did they fine each other in some kind of pact? Did an officer come in and assess the fines on each of them in turn? Next, the story of how Apache lost $2.4 million and set some case precedent all at the same time. The world of cybersecurity is extremely complicated. Organizations go to great technological lengths to protect themselves and their customers' data from any misuse or release or corruption. But in a recent case, scammers pretended to be a vendor of Apache and called one of its employees in the accounting department to set up a bank account change, directing company checks into the scammer's account instead. The scammer tricked the employee into making the change over the phone, then followed up the call with an email to the employee. After confirming the change, Apache inadvertently sent $7 million to the scammers. Apache's bank was able to stop some of the transactions, but $2.4 million was lost. Apache tried to claim that the loss through their insurance company, but was denied, so they sued to enforce the insurance policy. The Fifth Circuit Court of Appeals ruled that losses from a social engineering-based attack are not covered by computer fraud insurance. Apache made the insurance claim under part of its commercial insurance policy, claiming their policy covered losses resulting directly from the use of any computer to fraudulently cause a transfer of funds. But the Fifth Circuit Court of Appeals said that the email was merely incidental to the occurrence of the authorized transfer of money, and to interpret the computer fraud provision as reaching any fraudulent scheme in which email communication was part of the process would convert computer fraud to general fraud. To me, this means that there is now at least some clear law on how to interpret those insurance policies. Going forward, companies will have to take out a separate kind of insurance to protect themselves from losses from a social engineering-based attack. What do you think about that? Should social engineering attacks be considered cyber attacks and covered by cyber attack insurance? Or is this the necessary judicial process when parties don't write an agreement that is 100% clear on handling a particular kind of insurance claim? In lighter news, Hawaiian Airlines has won a case allowing it to weigh its passengers before boarding a flight between Honolulu and American Samoa. After discovering that most of its flights on this 2,600-mile route were overweight, the airline implemented a policy of pre-weighing passengers and seating them in order to balance the airplane. Passengers had complained that the policy was discriminatory, but the airline was able to show a genuine need, claiming that an uneven distribution of weight in the aircraft can cause a crash landing. 2 other airlines already weigh their passengers, beginning with Samoa Air in 2013 and Uzbekistan Air in 2015. Your thoughts? Several banks in London are now stockpiling bitcoins in order to conveniently pay off ransom demands from scammers who attack their IT infrastructure. Yes, you heard that right. Banks have found it easier to pay off at least some ransom demands rather than risk the loss if the threat is credible. These attacks often come in the form of a virus or malware that encrypts or otherwise denies access to a part of existing infrastructure or data until the affected organization pays a ransom through a website, usually via Bitcoin. Another form of this extortion is a threat to attack an organization's infrastructure, such as with a dedicated denial of service attack, unless a ransom is prepaid. The banks and police concede that they sometimes don't have resources available to deal with the large number of attacks that some organizations suffer, and the consequences can be dire. One telecom provider lost over 100,000 customers and 60 million francs in a cyber attack last year. But others worry that supplying attackers with additional funds via ransom will only encourage further and harsher attacks. What are your thoughts? Do we negotiate with cyber attackers? Should the community and industry work together to update our software and infrastructure to make these kinds of attacks more difficult, if not impossible? Now, I have a real fun story to get to that I think you'll really enjoy, but I want to get through one serious story first. The federal government of the United States is currently forcing over 10,000 military veterans to repay re-enlistment bonuses that were given to them, incorrectly as it turns out, by a master sergeant who fraudulently lavished troops with bonuses and forgave student loans in order to increase her re-enlistment numbers. The New York Times and the LA Times both report that the California Guard took advantage of an increase in enlistment bonus budgets from 2000 to 2008 by enticing veterans to re-enlist in an assembly line process which apparently did not pre-qualify them for the bonuses they received. A federal inquiry in 2010 found that as much as $100 million in improper bonuses was paid by Master Sergeant Tony Jaffe of Citrus Heights, California. Ms. Jaffe has since left the military and pleaded guilty to fraudulently approving more than $15 million in re-enlistment bonuses. However, that the fault lies with Ms. Jaffe and others who may have incorrectly approved and paid re-enlistment bonuses does not sway the U.S. government. who is going full bore on the collection effort, requiring soldiers to make large payments on large balances with short repayment periods. Those bonuses were used to encourage experienced soldiers to return to the battlefield and serve their country for additional years of their lives. Those soldiers counted on having that money available to them as their reward for their service when they returned home. Instead, their service was fraudulently obtained, and yet the government's stance is that the soldiers have to pay for that fraud. Soldiers who were already willing to pay their life for their country. That's an absolutely appalling and disgusting way to treat the people who were already willing to give everything. Hopefully the public outcry upon hearing about this inhumane treatment of our now re-enlisted veterans will sway our public officials to pass legislation that will nullify these balances. And now, for our final story, I thought I'd bring you some courtroom drama, the likes of which are rarely seen. While perusing an unrelated story on Reddit, I came across a video uploaded in 2006 from a Las Vegas courtroom where an attorney caused a mistrial by showing up to court intoxicated. Now, judges and their staff and other attorneys are usually pretty bright. That doesn't mean that they're bright in every way, but judges are people who see all kinds of defendants and attorneys all day, every day. So when someone walks into court who's a little bit drunk, you can bet that someone notices. And so this video begins with our judge graciously allowing the defense attorney to explain his late arrival and altered condition.
Mr. Caramingo, I want to address you first because it's my understanding you might have some problems this morning.
Judge, I was heading east on Sahara Drive and I was rear-ended and my car was undrivable. A good Samaritan drove me to the courthouse.
Who?
Over the course of the 30-minute video, which really takes place from about 11:45 to 1:45, the defense attorney offers varying explanations for his intoxicated state, starting with a claim that he had a concussion from a car accident during his trip to the courthouse. At first, he says he was rear-ended in a two-car collision. Then he says he rear-ended somebody else after the first collision, and that the other car simply drove off, and that he does not like calling the police for help. He says a friend was driving, but that friend is not in the courtroom. Then he says he called another friend to meet him at the courthouse for moral support as he was shaken up by the accident. The female friend, he claims, met him in the cafeteria and is now seated in the rear of the courtroom. Eventually, he confesses that he only met the woman 20 minutes before, but he is sure that they are good friends.
Hey, you know, Mr. Caramingo, you told me she was your ex-girlfriend. And so now I'm very upset with you.
I apologize, Your Honor. She was a friend. She was a friend of a friend. And I did ask her to come with me because I was nervous about coming to court late, and I did ask her to accompany me.
Eventually, the judge turns to the assistant district attorney, who testifies to having heard several versions of events and to the defense attorney slurring his speech.
Officer Vargas, it was represented to me that Mr. Caramingo made some statements to you when he came in. Is that correct?
Yes.
Could you tell the court what they were?
He's got in an accident, got rear-ended, and took over 2 hours for the cops to show up.
Took over 2 hours.
Something like that. Over 2 hours waiting for the cops.
Over 2 hours waiting for the cops.
Correct.
Okay.
Your Honor, I think I can reconciliate that.
Okay, because you told me that that officer wouldn't tell me that.
And Officer Vargas, as far as I know, is a gentleman. And what I said was that if I called the cops, it would have taken 2 hours. And I'm not disputing what he said, and I think it was a miscommunication.
Okay.
So I did not call the police. And I had my cell phone on me, and I'll give the court my phone records. And I just...
Oh, no, I believe you, but you don't like...
Pushed my car into the turn lane on Rancho, and he gave me a ride here. His name is Chris.
Okay. Is that could have been what happened, Officer Vargas? Could he have said, if I called the police, it would have taken over 2 hours?
That's not what I heard, but it's possible.
After pleading with the intoxicated attorney to tell the judge the truth, the judge orders a deputy to bring a breathalyzer.
Oh, if you came to court intoxicated, you have a problem. You can't even represent me anything so far. So
I apologize about the misrepresentation about the young lady.
Josephine's name was Christine. She was your ex-girlfriend. Turns out you only knew her for 20 minutes. You said you were rear-ended. Your car has absolutely no rear-end damage. Has substantial front-end damage. It's not even registered to you. It's registered to a person who's incarcerated in the Nevada Department of Corrections. I'm not quite sure it can get much worse. So just go ahead and blow. Let's get it over with. But let me tell you, my desire will not be to hurt you. It will be to help you. Okay, for the record, your blood alcohol is a .075.
When the breathalyzer reads .07, remarkably close to the legal limit for driving, and several hours after the alleged collision, the judge infers that the attorney must have been more intoxicated earlier, as well as still intoxicated now, and too altered to represent a client in a criminal kidnapping case. The judge declares a mistrial in the kidnapping case and graciously does not hold the attorney in contempt of court. But I imagine that attorney was sweating bullets both during and afterward. While I don't want to slander a fellow member of my bar, it certainly does appear, in my opinion, and without any corroborating evidence, that this person drove themselves to the courthouse while intoxicated, got into a car accident that might have been their fault, left the scene, possibly after exchanging information, but without calling the police, and then called a prostitute he did not previously know and met her at the courthouse to keep him company after his hearing. So, just wow. And while all that whole thing is hilarious in an awkward and spectacle sense, it also highlights a large problem that occurs in some industries like the legal profession, which has some of the highest incidences of alcoholism among all professions, as well as some of the highest rates of suicide and depression. So what do you think of Mr. Intoxicated Attorney? Was he really so wasted from the previous night of drinking that he was still registering a .07 at 1:45 in the afternoon the next day? Or is my speculation on the real version of events much more likely? Or do you have a scenario of what you think really happened? So that concludes our show for this week. I'd love to hear your thoughts and comments below about which story you enjoyed most, or which opinions you may have on each of these situations. I try to reply to as many of your comments and messages as I can. Thanks for watching. Your support and participation in this channel helps me bring better and better content to you. I'd like to thank my Patreon supporters not only for your support, but also for your wonderful comments and suggestions that make this whole thing so much more fun. If anyone would like to pledge, there's also a link in the upper right and in the video description. I'm Leonard French, your favorite copyright attorney, and I hope you have a great week.